dealing with who is actually the inventor here. And do you have any concerns about this dialogue that you're going back and forth with, or the information and then the draft, and then you go into the back and forth to refine? Any concerns about the AI being the inventor and not a human being an inventor, which then obviously creates a whole series of problems? And how do you guard against that?
Well,
I can jump in right away. No, go ahead, Thomas.
Good.
I do a fair amount of patent litigation, and inventorship is kind of the low argument on the pole, right? And these days, you rarely attack inventorship. It's a dog that won't hunt. But I predicted the future. This was going to be a big issue, right? As a patent litigator myself, that's what I'm going to do in the future. I'm going to look at one of Dean's patents and say, hey, those are the alternative examples. That weren't from your inventors. That was all AI generated. This whole thing is bogus. So it is something that you have to be very cautious about. And that's, I think, the way to safeguard against that is to you make sure that you document it, and that the patent attorney has kind of notes and kind of thinks about this, and that AI is assisting, but the conception always has to come from kind of a human being, and you always have to go back to the inventor and get kind of their buy off or agreement, and have that documented. I don't know how this is all going to play out in the future, but I predict in 3-5 years from now that we're going to see a flood, I don't know, flood of litigation, but you're going to see in the patent litigation context, this whole inventorship is going to be something that's going to be, it's going to be an issue. And I'm not sure the best way to safeguard against it other than to just be very cautious, and to make sure that you're working with a patent attorney that is going to be able to kind of defend and keep notes. And this is what the conception, and this is how I went about and drafted the patent.
So Thomas, let me follow up on that with you from the litigator's perspective. Does this change your idea of what patent practitioners should be keeping in their file? Because not to say anything nefarious. This is not to suggest anything that anybody does but there's all kinds of data retention policies, right? And typically you get to the end and you go through the file, and we get rid of X, we get rid of Y, we get rid of Z, we keep A, we keep B, we keep C. And as long as it's uniform and you're not just throwing stuff away, then it's neutral, right? But does this change what your quote unquote neutral policy ought to be in terms of file preservation?
I don't have the answer to that, Gene. It's just something you have to be aware of. And as patent practitioners, we just have to be cognizant and do the best that we can, and kind of make sure that we don't overstep the bounds of the invention. I mean, these are such powerful tools, right? That you in some ways don't need much of an inventor. An inventor can just give you a seed, and you can get a whole tree, from that. So
But that doesn't, what you just described, the seed, the getting a tree from a seed is sort of what goes on now in a lot of cases, right? As we were talking about, you get the,
we did. And in the past, that attack of inventorship is like, well, someone had invented it. It wasn't the inventors who did, right? So you say, now you're going to have this dummy, right? Well, it was
yeah.
AI, wasn't the inventor. So it's a different gene. It's a different future.
It is, and I wonder because, like just as we were talking about it, it popped in my head, right? Like the question is different. We always, I'll just say it, in probably half or three-quarters of cases, it's the patent attorney that is the inventor, or maybe not the inventor, but an inventor, right? Well, that's a living person who can qualify to be an inventor. And if it turns out later on, it's easy enough to fix inventorship. It's not a problem. It's the lowest hanging of fruit, right? But if it
Or it's
turns
not
out
the
that
other
it
way
was the
too,
AI
right?
that was the inventor, now you got an issue.
Yeah, that's right. I mean, it's like in federal court now, this whole inventorship issue, it's just your litigators aren't going to bring that up because it's a
Right.
losing argument, right? It's like you can fix it.
Mhm.
It's going to be somebody. It's not persuasive. But in the future, it's not going to be such a losing argument, right?
Right.
We're talking about $100 million technology, and I'm the defense counsel. My client is being sued. I'm going after the patent prosecutor, all right, and saying you used these AI tools, you didn't invent it.
Yeah.
That's going to be my argument. So how are you
So
going to?
that's why it becomes really important for prosecutors to keep a record, a good, I think, record of what
Absolutely.
happened, how things got added, the prompts, the back and forth. Um,
I don't know the level of detail there, Gene, but you have to be able to pin back the claims, all the elements of the claims, all the limitations,
mhm.
every aspect of it, right? To a human at some point. How are we going to do that? I don't know. You're right.
Yeah.
So
If I may
my
interject,
I would add,
oh, go
I
ahead.
would add one thing.
Let Samir go. Samir.
Okay.
Right. I'll just mention a couple. This argument to me sounds a little bit like those arguments that these Sam Altmans of the world will say, the AGI is coming, the artificial general intelligence will take over the world. Let's. I think the truth is somewhat more mundane, right? Like the mundane truth is that here we have basically a Microsoft Word, plus plus kind of a platform where you are providing your inputs, where everything is being tracked. There's version control of every input you gave and every output you gave and so on, right? The models are, they're smart, but they're not like crazy intelligent. They are proposing certain things, but they're not like, so to a great extent, I believe that good hygiene, right? Like where we are tracking, as what Eugene and Thomas are talking about, like tracking and being very disciplined about your process, will go a long way, keeping the inventor informed about what you are putting in the patent application, etc. I feel that good hygiene that we have already built in the platform will go a long way. And beyond that, I feel that there's some level of alarmism here that we should probably not give in to so easily.
Yeah,
But
yeah,
that's
yeah.
just my kind of like,
Because I don't think it changes a lot, right? I mean, because I think patent attorneys have been or should have been listed as inventors for a very, very long time. What I do think, and what I think that this does do gives you is the opportunity to have that good hygiene where you can say, oh, no, I can tell you where this came from. I can tell you how this got in there, and I can, you could dial it back. And I like the version control, I think is very, very important in this. And that's one of the things I wanted to point out, because I do think that people get worried about this sort of thing. And the tools are not at the point where you're going to say, like you hear these crazy things, like tell the AI, I want you to invent every possibility of a chair and spit it back out at me. Okay, well, that's not how, it's smart, sort of, but it's smart in that it follows the lead, I think, and you direct the tool, you use it as a directing tool to uncover, give me more of this, give me an example that does A, B, and C. Well, if I say, give me an example that adds these three compounds together in this way with this bond, and you gave me the example, well, I could have figured that out. I mean, it's not like well, maybe not me because I'm an electrical engineer. I couldn't figure that out for sure. But you all who are chemical smart could figure that out, and it's much faster like that with the tool.